Picture a newborn's first breath in a hospital room in Houston. The fluorescent lights hum overhead. A mother's exhausted smile. A father's trembling hands holding a birth certificate that reads, "Citizen of the United States." For 157 years, that document has meant something absolute, something unchangeable, something that connects a child to the soil where they drew their first breath, regardless of where their parents were born or how they arrived. But on a cold January morning in 2025, the meaning of that piece of paper began to fracture. Not in delivery rooms or immigration offices, but in the marble halls of the Supreme Court, where 9 justices would decide whether being born American still makes you American. Where the most fundamental question of belonging would be reduced to legal arguments and constitutional interpretation. Where millions of children would discover that the ground beneath their feet was never as solid as they believed. Have you ever wondered what happens when the most basic assumption about citizenship suddenly becomes negotiable? When a single executive order can redefine what it means to be born American? This dramatized narrative is inspired by real legal principles and public case records. It is presented for educational and entertainment purposes, with interpretations attributed to their respective sources. The morning of January 20th, 2025 began like any other inauguration day. Crowds gathered, cameras rolled, history prepared to turn another page. But tucked inside the ceremony's pageantry was a document that would challenge the very foundation of American identity. Executive Order 14,160. 23 pages that would attempt to rewrite 157 years of constitutional law with the stroke of a pen. The order carried an innocuous title: Protecting the Meaning and Value of American Citizenship. But beneath those careful words lay the most aggressive challenge to birthright citizenship since the Chinese exclusion era of the 1880s. The document didn't simply propose new immigration policy. It fundamentally redefined what the 14th Amendment had meant since 1868. The amendment's language seemed clear enough. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. But Executive Order 14,160 focused on 5 words that had rarely been questioned. Subject to the jurisdiction thereof. The order declared that children born to mothers who were in the country unlawfully, or mothers whose presence was temporary and lawful, would no longer be considered subject to American jurisdiction, no longer citizens by birth. The implications were staggering. Hundreds of thousands of children born annually on American soil would suddenly find themselves without a country. Not citizens of the United States where they were born, often not citizens of their parents' homeland either. Stateless. Within 24 hours of the order's signing, the legal challenges began. Not from radical activists or political organizations. From immigration lawyers, civil rights advocates, and state governments who understood what was at stake. CASA, an immigrant advocacy organization, filed the first lawsuit in federal court in Maryland. Their argument was straightforward. The executive order violated the 14th Amendment. Period. On February 5, 2025, a federal judge agreed. Judge Sarah Mitchell issued a preliminary injunction blocking the order from taking effect. Her reasoning was rooted in more than a century of Supreme Court precedent. The 1898 case of United States versus Wong Kim Ark had settled this question definitively. Children born on American soil were American citizens regardless of their parents' status. The judge's injunction was nationwide. From California to Maine, the executive order was frozen. But this was only the beginning of a legal battle that would reshape not just citizenship law, but the entire structure of federal litigation. 2 more federal judges in separate districts issued similar nationwide injunctions. 3 different courts, 3 different judges, all reaching the same conclusion. The executive order was likely unconstitutional. The government could not enforce it anywhere in the United States. For decades, this type of nationwide injunction had become routine. When federal policy was challenged, a single federal judge could block its implementation across all 50 states. The practice had frustrated presidents of both parties. George W. Bush faced it. Barack Obama faced it. The first Trump administration faced it constantly. Joe Biden faced it too. But now the Supreme Court was ready to intervene, not necessarily on the constitutional question of birthright citizenship, on something more fundamental, whether federal judges had the power to issue nationwide injunctions at all. The government's emergency petition to the Supreme Court was surgical in its focus. They weren't asking the court to rule on the 14th Amendment. They were asking whether 3 federal judges had the authority to block executive action across the entire country, whether the judicial branch had exceeded its constitutional role. The question split legal scholars. Some argued that nationwide injunctions were essential to prevent a patchwork of conflicting federal policies. Others contended that single judges wielding national power violated the separation of powers. Both sides could cite history, precedent, and constitutional theory. As you listen, notice how easily this could be anyone's life. The Supreme Court agreed to hear the case on an expedited schedule. Trump versus CASA would be decided by June. The arguments would focus on judicial power, not citizenship rights. But everyone understood that the future of birthright citizenship hung in the balance. The case attracted unprecedented attention from legal observers, not just because of the citizenship implications, but because the court's decision would fundamentally alter how federal litigation worked. If the court ruled that nationwide injunctions were impermissible, the consequences would ripple through every area of federal law. Environmental protection, healthcare, immigration, civil rights. Any federal policy could potentially be enforced in some states while being blocked in others. The oral arguments in May revealed a court deeply divided along familiar lines. The conservative justices questioned whether Congress had ever granted federal courts such broad, equitable power. Justice Barrett pressed the government's opponents on historical precedent. When did federal courts first start issuing nationwide injunctions? Could they point to similar practices in English common law or early American jurisprudence? The liberal justices focused on practical consequences. Justice Sotomayor painted vivid scenarios of federal chaos. What happens when Social Security operates differently in different states? When environmental regulations apply in California but not Texas? When citizenship itself becomes geography dependent? But beneath the legal technicalities lay deeper questions about power and democracy. Who decides what federal law means? Can a single federal judge overrule the executive branch for the entire nation? Should they be able to? The answers would determine not just the fate of Executive Order 14,160, but the balance of power between the branches of government. The historical context made the stakes even clearer. The 14th Amendment had been ratified in the shadow of the Civil War. Its authors had deliberately chosen broad, inclusive language. All persons born, not some persons, not persons whose parents met certain criteria, all persons. The amendment was designed to overturn the Supreme Court's decision in Dred Scott versus Sanford, which had declared that African Americans could never be citizens. The Wong Kim Ark case in 1898 had extended this principle to immigrants' children. Wong Kim Ark was born in San Francisco to Chinese parents who were prohibited by federal law from becoming citizens themselves. When he returned from a trip to China, immigration officials denied him entry, claiming he wasn't American. The Supreme Court ruled 6-2 that his birthplace made him a citizen. The 14th Amendment's language was clear and broad. Birth on American soil, combined with being subject to American jurisdiction, created citizenship automatically. For 125 years, this precedent had remained undisturbed. Republican and Democratic administrations alike had accepted its validity. Children of immigrants, tourists, temporary workers, even people in the country unlawfully became citizens simply by being born here. It was one of the most settled principles in American law. Executive Order 14,160 challenged this understanding by reinterpreting subject to the jurisdiction thereof. The order argued that temporary visitors and unauthorized immigrants were not truly subject to American jurisdiction because they owed allegiance to other countries. Their children, therefore, would not inherit birthright citizenship. Legal scholars noted the irony. The same phrase that had been used to exclude Native Americans from citizenship in the 19th century was now being used to exclude immigrants' children in the 21st. History rhyming across centuries. The human stories behind the legal arguments were heartbreaking. Children born in American hospitals who might suddenly find themselves without any nationality. Parents who had believed their children's citizenship was secure, discovering it was contingent on judicial interpretation. Families split between citizen and non-citizen siblings based on the timing of their births, but the case that would decide their fate wasn't really about them at all. It was about judicial power, about whether federal courts could continue issuing nationwide injunctions. The Supreme Court had chosen to address the constitutional crisis through procedural law rather than substantive constitutional interpretation. On June 27, 2025, the Supreme Court released its decision. 6 justices to 3. Trump versus CASA held that federal courts lacked the authority to issue universal injunctions under the Judiciary Act of 1789. Justice Barrett's majority opinion traced the history of equitable remedies back to English common law. Nationwide injunctions, she wrote, had no historical pedigree. They were a modern invention that exceeded the judicial power Congress had granted to federal courts. The decision was narrow but revolutionary. The court didn't rule on whether Executive Order 14,160 was constitutional. It simply held that federal judges couldn't block its nationwide implementation. The 3 district court injunctions were dissolved. The executive order could now take effect, at least until individual plaintiffs obtained court orders protecting their specific situations. Justice Sotomayor's dissent was passionate and prescient. She warned of the chaos that would follow. Federal law would become a patchwork of different rules in different jurisdictions. Children would be citizens in some states, but not others. The uniform application of federal law, a cornerstone of American governance, would crumble, but the majority was unmoved. Federal courts, Justice Barrett wrote, resolve cases and controversies. They don't exercise general oversight of the executive branch. When Congress wanted to grant broader, equitable powers, it knew how to do so. The Judiciary Act's silence on universal injunctions was telling. The decision fundamentally altered American litigation. Clients could no longer assume that favorable rulings would protect them automatically. Each person seeking protection from federal overreach would need to file their own lawsuit. The era of single judges blocking national policies had ended. The phone call comes at 3:17 a.m., a voice on the other end shaking, barely audible above the fluorescent hum of a hospital corridor. "My daughter was born 3 hours ago," the voice whispers. "They're telling me she might not be a citizen." Somewhere in that sterile hallway, between the miracle of birth and the machinery of bureaucracy, a question hangs in the air that no parent should ever have to ask. What country does my child belong to? The ground beneath our feet, the documents we carry, the promises we inherit from previous generations, all of it suddenly feels fragile. Suddenly feels as if citizenship itself were nothing more than a signature on paper, subject to revision, vulnerable to the whims of power and the interpretations of judges who will never know your child's name. In that hospital room, holding a birth certificate that might mean everything or nothing at all, a parent discovers that belonging is not a birthright. It's a legal argument waiting to happen. The morning Executive Order 14,160 was scheduled to take effect. July 27, 2025, maternity wards across America held their breath. This dramatized narrative is inspired by real legal principles and public case records. It is presented for educational and entertainment purposes, with interpretations attributed to their respective sources. The Supreme Court's decision in Trump versus CASA had dissolved the legal barriers. 3 nationwide injunctions swept away in a single ruling that reshaped federal litigation forever. But the human consequences were just beginning to unfold. In hospitals from Miami to Seattle, doctors, nurses, and administrators faced questions they had never been trained to answer. How do you determine a newborn's citizenship status? What documents do you file when the law itself is in flux? The chaos was immediate and profound. In Texas, a child born to parents on tourist visas found herself in legal limbo. The hospital issued a birth certificate, but the State Department refused to process a passport application. In California, immigration attorneys fielded panicked calls from families whose children, born just hours earlier, might face deportation to countries they had never seen. The executive order's language was clinical, bureaucratic, but its impact was deeply human. Children who had been American citizens by birthright for generations suddenly found their status dependent on their parents' immigration paperwork. Families discovered that siblings born months apart might have different citizenship statuses based on nothing more than timing and judicial interpretation. Immigration lawyers worked around the clock, filing individual lawsuits for each affected family. The Supreme Court's ruling in Trump versus CASA meant that nationwide relief was no longer possible. Each child needed their own court case, their own judge, their own legal battle for recognition as an American citizen. The patchwork of litigation created exactly the kind of chaos Justice Sotomayor had warned about in her dissent. In the Eastern District of New York, Judge Maria Rodriguez granted temporary restraining orders protecting children born to families within her jurisdiction. But across the river in New Jersey, Judge Thomas Chen ruled that the executive order was constitutionally permissible and declined to issue similar relief. Federal law, for the first time in modern American history, was being applied differently in different places. A child born in Manhattan might be a citizen, while an identical child born in Newark might be stateless. The uniformity of federal law, a cornerstone of American governance since the founding, had fractured along jurisdictional lines. The Department of Homeland Security struggled to implement the new policy. Field officers received conflicting guidance about which children to process for citizenship documents and which to deny. Some regional offices continued processing applications as if nothing had changed, while others implemented the executive order strictly, creating a bureaucratic maze that trapped families in administrative purgatory. Meanwhile, the constitutional challenge to Executive Order 14,160 itself continued through the courts. The Supreme Court's decision in Trump versus CASA had addressed only the procedural question of nationwide injunctions. The substantive constitutional issue, whether the executive branch could redefine birthright citizenship through executive action, remained unresolved. Legal scholars debated whether the executive order could survive constitutional scrutiny. The 14th Amendment's language was broad and inclusive. The Supreme Court's precedent in Wong Kim Ark was clear and long-standing. But constitutional law is not mathematics. Precedents can be overruled. Amendments can be reinterpreted. The court that had limited judicial power in Trump versus CASA might be willing to limit constitutional rights as well. The human toll mounted daily. Children born to immigrant parents found themselves unable to obtain Social Security numbers, blocking access to health care, education benefits, and basic government services. Families faced impossible choices: leave the country with American-born children who might be denied re-entry, or remain in legal limbo with children whose status could change based on the outcome of ongoing litigation. As you listen, notice how easily this could be anyone's life. The psychological impact on affected families was profound. Parents who had believed their children's citizenship was guaranteed by the Constitution discovered that constitutional rights were subject to political interpretation. The document they had trusted as sacred and permanent revealed itself as fragile and contingent. Maria Gonzalez, whose daughter Sophia was born 3 days after the executive order took effect, described the experience in testimony before Congress months later. "I held my American-born daughter and wondered if she belonged anywhere," she said. "The hospital gave us a birth certificate that said, 'born in the United States.' But the government said that didn't make her American. How do you explain to a child that the country where she was born doesn't recognize her as its own?" The legal battles continue today. Scattered across dozens of federal courtrooms, each family fighting individually for what was once guaranteed collectively. Children grow older in the shadow of uncertainty, their citizenship status dependent not on the soil where they were born, but on which judge happens to hear their case. In the end, Trump versus CASA changed more than judicial procedure. It revealed how fragile our most fundamental assumptions really are. How quickly the ground beneath our feet can shift when power decides to reinterpret the words we thought were written in stone. The birth certificate still reads the same. The hospital room still hums with the same fluorescent light. But somewhere between the promise of the 14th Amendment and the reality of executive power, the meaning of being born American became just another legal argument waiting to be decided. Perhaps that's the shadow behind justice. Not that it fails to exist, but that it exists only as long as we continue to believe in its permanence. And sometimes, in the space between one Supreme Court decision and the next, we discover that even our deepest beliefs about belonging are nothing more than interpretations subject to revision by 9 justices we will never meet. The children at the center of this case will grow up knowing something their parents never had to learn. That citizenship, like justice itself, is not a birthright. It's a promise that each generation must fight to keep.